And while we are talking right now about the bizarre bail conditions, that the Juvenile Justice Board put up while granting bail to this boy just 15 hours after he was detained by the police, another story has come up today that appears to, add a layer to the entire conversation. The Supreme Court on Tuesday, viewer, in a separate incident, a separate case altogether, refused to grant bail to an underage boy belonging to Uttarakhand, accused of making obscene videos of his classmate and circulating it. The classmate, this young girl, committed suicide later. The denial of bail from the top court comes amidst this Pune accident case, where bail was granted by the Juvenile Justice Board to this 17-year-old. A vacation bench of Justices Bela M. Trivedi and Pankaj Mittal upheld the Uttarakhand High Court order, which had refused to grant bail to this minor, to this underage boy in this particular case. The boy has been booked under sections 305 and 509 of the IPC and different sections of the POCSO Act. So this is just not a related case, a completely separate case where an underage boy has been denied bail, seeing the gravity of this particular case. Now, I want to get an expert legal view on this particular case, and there are few better than Satish Maneshinde, who's one of India's most well-known criminal lawyers, most respected legal voices. Mr. Maneshinde, welcome, sir. Thank you very much for your time. It's a case that has thrown up a great deal of emotions, but as you know better than anyone else, the law itself is not a place for emotions. There are rules, there are laws, and due process must be followed. The police in this particular case, Mr. Maneshinde, have said that they want this minor, he's 17 years old, to be tried as an adult in the case. The basic facts of the case are known at this point of time. What is your take on that, sir? Can he be tried as an adult?
Well, he could be tried as an adult, but I must tell you that right from the inception, at least when the matter came out in public arena, an impression was created in the media and social circles that the Juvenile Justice Board must have made a mistake in releasing him on bail. But on examining the FIR, which was registered at 8:13 on the 19th, and the application made by the police before the Juvenile Justice Board for trying him as an adult under Section 18 of the Juvenile Justice Act, I presume, and I am of the firm belief, that right from the inception, the entire criminal administration system, criminal justice system has been tampered with. And there are a few reasons why I have come to this conclusion.
Yes.
One is that the accident took place at about 2:30 a.m. early morning on the 19th and 20th of May. Apart from all that, the FIR is registered at 8:13. The bodies of the two victims, when they were still injured, were carried to the police to the hospital immediately by the first informant. And on reaching the hospital, they were informed that they were both deceased. So obviously, immediately the police would have been informed. They must have swung into action, and the boy was apprehended and taken to a police station, because till then nobody knew his age. The fact that a local MLA reaches the police station at 3 a.m. and remains there till whatever is done tells me that the entire justice system has been tampered with, because if the boy was apprehended at 2:33 a.m., there is no reason why an investigating officer who apprehends him would not smell liquor on his person.
Correct.
Because the investigations and the revelations made now is that the boy drank alcohol worth 48,000 rupees at first pub. Subsequently, they went to the next place, Black Pub, and they consumed there till 2:30. So obviously, they were reeking of alcohol, and any person who comes in contact with the victim or the accused who is brought to the police station would smell him of liquor. So the first thing that the police officer should have done particularly when he has come to know that the two victims were deceased already by 3
Yes.
a.m., he should have sent that boy for a medical checkup immediately to obtain his blood samples.
Yes.
This has been done after 15 hours after the
Correct.
accident, which tells me that the police officer in charge of the police station at that particular time derail the entire judicial system and the criminal administration system
Yes.
by making sure that the boy is sent at a delayed response to the hospital for taking blood samples. Apart
Yeah.
from that, what was the police officer doing from 3 a.m. till 8:13 when the FIR is recorded obviously tells me that a lot of things have happened. If the
Yes.
local MLA was there, his mobile should be confiscated. If the parents knew of the accident, because moment a person discloses that he is a minor, the officer in charge of a police station or child welfare officer which is in the police station is
Yes.
duty bound under the Juvenile Justice Act to inform the parents that their boy is there in their custody and he should come and take care of the child so
Correct.
that there is no harm to the child under the Juvenile Justice Act. So obviously this has been done, and the fact that they produced the boy through the juvenile probation officer before the learned judge or the Juvenile Justice Board would have been only under 304A because the FIR was
Yes.
registered under 304A initially
Negligence.
at 800, 8:13 in the morning. So
Hmm.
obviously there was no offence registered which could disclose to the Juvenile Justice Board that 304 Part 2, which is a serious offence,
Yes.
heinous offence, it was disclosed. Obviously, the Juvenile Justice Board may not have been aware of the entire facts of the case, and probably they released the boy on bail. But the Juvenile Justice Act makes three categories of offences: petty offences, serious offences, and heinous offences. Those
Right.
offences are petty. The person can be released forthwith to the custody of the parents.
Yes.
In a serious offence, he will have to impose all those conditions which Juvenile Justice Board has imposed now. If the
Right.
Juvenile Justice Board was aware that it was a heinous offence and in spite of that they released him on bail, means it's a serious infraction under the law, and I'm sure a higher court or the High Court in its capacity in the judicial side as well as the administrative side should look into the functioning of the Juvenile Justice Board. Now the
Right.
fact that the person is almost reaching the age of 18 means that if a person is accused of an heinous crime, particularly where two deaths have been caused under the influence of alcohol, the boy, even if he is a minor, if he is drinking in a pub repeatedly from 10:30 onwards till 2:30 a.m., obviously he knew the consequences of consuming liquor. Number
Yes,
one. Number
absolutely.
two, in Alistair Pereira's case, the Supreme Court has said, that if a person under the influence of alcohol sits behind the wheel, he has full knowledge that he is likely to cause death of people on the road. Obviously, this boy, if he has been used to these kinds of habits and he has been given custody of a vehicle which is worth more than 2.5 crores and has been driving a vehicle, he had full knowledge of what was going to be caused. So this boy can be tried before the children's court, or
Okay.
if the children's court is not in existence in Pune, he will be tried before the Honorable Sessions Court in Pune. But the fact that he has been released on bail in spite of this heinous crime
Yes.
means that there is a complete derailment of justice at the hands of the Juvenile Justice Board if it is aware that a heinous crime was committed. Because even before a person is released on bail, under Section
Absolutely.
15 of the Juvenile Justice Act, there is a preliminary assessment to be carried out even for a petty offence, serious offence, or a heinous offence.
Right,
If the
right.
person who was sitting on the bench was aware that this person the accused has consumed alcohol, obviously the learned judge or the Juvenile Justice Board should have sent him to an observation home, because this man was completely, the boy was completely in requirement of observation in the remand home as well
Okay.
as a psychiatric treatment, because a boy under the age of 18 years
So-
cannot be consuming liquor, And if he's consuming liquor, obviously he is infracting the law.
So derailment of the process, tampering. Mr. Maneshinde, you've answered all of the questions I had with that very comprehensive view. So I'd like to thank you for that. You've given us a great deal to also take our coverage forward and ask these big questions. It carries much greater gravitas when it comes from someone of your stature. So I appreciate you for taking the time out and adding your wisdom on our coverage here on India Today. Thank you so much, sir.
The Commissioner of Pune has made a statement.
Yes, he has.
The Commissioner of Pune has made a statement before the media as well as in the print that he will suspend the entire police station. This is more than a reason for him to suspend the entire police station and also take action against the local MLA who tampered with the investigation.
From the Ajit Pawar NCP. We will be keeping a very close track of that, sir. Thank you very much for joining us. Thank you, sir.
Whoever it is.
Yes, absolutely. Thank you so much.
Thank you.